The freeze of federal grant and contract funding by the Trump administration in January has triggered a crisis that revealed significant vulnerabilities in how many nonprofits obtain and secure federal funding. Subsequent Supreme Court decisions and congressional actions have permanently altered the legal and political landscape. Nonprofits now face threats from all three branches of government and must fundamentally rethink their legal advocacy, political engagement, and financial sustainability strategies. To help nonprofit health and human service leaders track and respond to these threats, the Atrómitos team developed a policy brief and a blog post. Today, I'm speaking with the brief's co-authors, Michealle Gady, founder, president, and CEO, and Devon Cavaliere, legal intern extraordinaire. Michealle, what prompted you to write this policy brief in September when a lot of stuff happened in January?
So we wrote the brief in response to what we were seeing as threats to nonprofit funding from all three branches of government. In January, the OMB memo came out and it froze billions of dollars in federal aid overnight. But then the Supreme Court decisions and congressional action exposed what we see as serious vulnerabilities in nonprofit funding security. So while the January memo indicated the administration's willingness to make these changes, action subsequent to that has indicated that the other two major branches of government are willing to engage in this. And so from our perspective, the January freeze was the start of a bigger effort to change how federal funding works. And we want to make sure that nonprofit leaders understand this.
So Devon, what does the Office of Management and Budget, or OMB, do? And what's the significance of their January 27th memo?
The Office of Management and Budget is a federal agency within the executive branch responsible for administrating the federal budget and overseeing the performance of federal agencies. They possess the authority to establish comprehensive financial management policies and establish related requirements for agencies within the executive branch. OMB memoranda serve as directives and implementation guidance for specific requirements and priorities, providing agencies with the necessary instructions to adhere to these standards. The OMB memo on January 27th directed every federal agency to temporarily pause all activities related to obligation or disbursement, to allow the administration time to review programs and align funding with the president's priorities and the law. The directive caused chaotic and confusing communication among federal, state, and local agencies. The freeze specifically implicated activities related to recent executive orders, including financial assistance for foreign aid, non-governmental organizations, diversity, equity, and inclusion. Nonprofits, states, and public health officials viewed the funding freeze as a massive, reckless, and potentially devastating attack on the nonprofit sector and the communities they serve.
The memo was rescinded in just one day, but you note that 8 months later, some organizations are still waiting for funding decisions. What happened during that period, and what are the lingering effects?
Yes, so the memo was rescinded not even 48 hours later. However, the brief period during which the memo was active, coupled with political momentum, caused significant and lasting upheaval in federal funding. During that period, there was administrative confusion and initial compliance, where federal agencies adopted varying approaches to comply, and there was also immediate legal action. Nonprofits and state governments swiftly challenged the directive. The lingering effects stem primarily from the immediate administrative chaos the freeze caused and the subsequent litigation and policy decisions.
What executive orders drove this funding freeze, and which impacted nonprofit health and human service providers the most?
The freeze was driven by 7 specific executive orders, which generally signaled a broad policy shift away from priorities related to diversity, equity and inclusion, gender ideology, immigration, and climate initiatives. The executive orders that impact nonprofit health and human service organizations were ending radical and wasteful government DEI programs and preferencing, defending women from gender ideology extremism and restoring biological truth to the federal government, ending illegal discrimination and restoring merit-based opportunity, protecting the American people against invasion, and enforcing the Hyde Amendment. Nonprofit health and human service organizations were heavily impacted by the OMB memo because many of the programs explicitly targeted by the executive orders fall within the social and health services sector.
Michealle, based on your experience working with these types of organizations, what were nonprofits experiencing during this period, and how did it feel on the ground?
So, as Devon has alluded to, the experience on the ground was rather chaotic. Some organizations, shortly thereafter the release of the memo, even though it was rescinded, some organizations couldn't access the federal payment systems that they had relied on for years. So one day the funds were available to pay staff and rent, and the next the systems were completely shut down. Adding to that, the memo's vagueness created a lot of uncertainty. So no one was really sure which programs were affected and what they should do. And so even though the memo was rescinded, the White House indicated that the objectives of the OMB memo were still in effect. And so from that, it was a very chaotic short period of time, but the responses from the federal agencies were quite varied. And so that also added to the chaos. So not only could systems not be accessed that usually were accessible, explanations or directions or any information from the federal agencies either didn't happen because, some federal agencies just didn't communicate because they didn't know what was happening, while others were communicating, but what they were communicating wasn't very clear because communication with them wasn't clear. So lots of, chaos essentially, because some federal agencies decided just to stop doing anything until they got clear instructions, while others intended and continued to operate and do things until they got clear instructions. So it was very different from agency to agency. And even within an agency, it could have been different from program to program or department to department.
So meanwhile, while all of this chaos is ensuing, nonprofits around the country were dealing with the results, and several national nonprofits and states challenged the administration's funding freeze in federal court. Two major lawsuits were filed on the same day, January 28th. Can you tell us about the National Council of Nonprofits and the State of New York cases? Describe the key legal arguments in each case. How are they similar or different?
Yes, so both lawsuits asserted two of the same arguments. They said it was arbitrary and capricious, meaning they both stated that the memo lacked a reasonable basis for pausing fund disbursement and failed to consider the catastrophic practical consequences of an immediate across-the-board freeze, and that the OMB memo was in excess of statutory authority, saying that the OMB and the president acted beyond their legal bounds. However, the National Council of Nonprofits argued that the OMB's statutory authority for financial management did not allow them to unilaterally terminate all federal financial assistance programs, and the states argued that neither the president nor OMB has the constitutional or statutory authority to order a government-wide pause or refuse to disperse funds appropriated by Congress. However, they differed in their specific constitutional claims, which reflects on the difference between the plaintiffs being one a group of nonprofits and other organizations and one a group of states. The National Council of Nonprofits, in their case, they argued that the memo violated their First Amendment rights by burdening political speech and discriminating based on viewpoint. They argued that in order to continue to receive federal funding, recipients had to abandon political, personal, and moral viewpoints disfavored by the administration. The states felt the memo violated the separation of powers doctrine by refusing to disperse funds appropriated by Congress, which usurps the legislative function. They also felt it violated the spending clause by imposing ambiguous conditions on obligated grants, altering the terms contrary to congressional authority, and that it also violated the presentment, appropriations, and take care clauses by constituting an unauthorized refusal to spend money appropriated by Congress.
So both cases, I understand, secured a preliminary injunction. What does that mean? Try to translate your legalese. And how significant was that victory at the time?
So a preliminary injunction is a pre-trial court order that temporarily halts the challenged action until a final judgment can be reached. To grant a preliminary injunction, the judge weighs the extent of irreparable harm and the likelihood of the plaintiff prevailing. Securing this relief was significant because it prevented the immediate implementation of a broad and chaotic funding freeze.
What were these organizations and states hoping to achieve with these lawsuits, and why was speed so critical?
The goals of the lawsuits were to compel the resumption of the obligation and disbursement of previously promised federal assistance, to obtain a legal declaration that the OMB memo was unlawful, and ultimately to obtain a permanent injunction, which is a court order issued as a final judgment that would permanently require the defendants to stop enforcing the OMB memo. Speed was critical because the OMB memo set an extremely short deadline, and implementation was feared to cause immediate and devastating harm. This harm included financial chaos and disruption of essential services.
There was a game-changing Supreme Court ruling in June of 2025. Devon, could you describe this ruling in the CASA case and tell us how this decision fundamentally changed the impact of these lawsuits?
Yet the Trump v. CASA case addresses the scope of judicial power. The Supreme Court ruled that federal courts generally lack the authority to issue nationwide or universal injunctions, unless such a broad order is necessary to grant complete relief to the plaintiffs before the court, meaning the only way they would grant or issue a universal nationwide injunction was if it would provide relief for the plaintiffs that are a part of the case. So any party that might be harmed that is not a part of the case, they would not receive relief that they normally would. So this decision fundamentally alters the legal landscape by restricting the ability of lower federal courts to issue sweeping orders that protect non-parties.
So can you expound a little more on how the CASA lawsuit has changed protections? Can you expound on that a little more, please?
Yeah, before the CASA ruling, a successful lawsuit challenging an executive action under the Administrative Procedure Act would typically lead to protections for all affected parties, regardless of if they were named plaintiffs in the lawsuit. Now, after CASA, the ruling means that injunctions are restricted and that relief will only be granted, or that relief is limited to the plaintiffs who are a part of the lawsuit, the plaintiffs who brought the suit.
The court mentioned class action lawsuits as an alternative. Is this a viable path for nonprofits?
So a class action is a viable potential alternative. However, it's also cumbersome and potentially very difficult. Class action lawsuits are a pathway to nationwide protection. They're efficient. They have lower upfront costs. There's strength in numbers, and they're a catalyst for change. However, they're very complex. There's a loss of control if you're not the leading party, and there's limited compensation.
So we've discussed how the actions of the judicial branch will affect nonprofits. Next, let's move to the executive branch and its $783 million cut to the National Institute of Health grants, which fund public health and biomedical research. Devon, can you explain what happened with these NIH grants and why the Supreme Court allowed these grant terminations to proceed?
Yes, so this action followed a series of executive orders that targeted programs related to DEI and gender ideology. The NIH issued internal guidance documents stating it would no longer fund research related to DEI objectives, gender identity, or COVID-19, and terminated research grants. So a group of plaintiffs, including the American Public Health Association and a coalition of states, challenged the termination of grants. The U.S. District Court for the District of Massachusetts ruled the terminations and guidance documents were arbitrary and capricious, and a violation of the APA, or the Administrative Procedure Act, and it vacated both. However, the Supreme Court granted the administration's request for a partial stay, allowing the NIH to terminate the grants linked to DEI and gender identity research. The court's reasoning was based on jurisdiction and the Tucker Act. The court believed that the district court likely lacked jurisdiction to hear challenges to the specific grant terminations. They also determined that challenges related to specific grant terminations are viewed as a contract dispute that belong in the Court of Federal Claims under the Tucker Act. The court determined the federal government would face irreparable harm if required to continue spending funds on grants it might not be able to recoup.
Maybe what you lawyers call a jurisdictional split. What does that mean for organizations trying to restore their funding? And what about those organizations that are seeking complete relief? How does it impact them?
So the court split the outcome, allowing the district court ruling that vacated the NIH guidance documents to remain in place. This is what created the jurisdictional split, or two-track litigation, forcing plaintiffs to pursue different parts of their legal challenge in separate courts based on the nature of their claim. One, the policy challenge, so challenges to the underlying policy directives like the NIH guidance or the OMB memo remain in federal district court under the Administrative Procedure Act, the APA. The goal is the vacature or setting aside of unlawful policy. The second piece is the contractual claim. So claims challenging the specific individual grant termination decisions must be filed separately in the Court of Federal Claims, the CFC, under the Tucker Act. So for organizations seeking grant restoration, the split makes the process significantly more difficult and complicated. They now have to navigate two separate court systems. This split severely undermines the ability of organizations to obtain complete relief. Even if the district court finds that the policy is unlawful, it cannot order the payment or reinstatement of grants because those are contract claims for the CFC. However, the CFC generally lacks the general power to provide equitable relief against the government.
While the court cases were playing out, Congress, in the meantime, passed the Rescissions Act. Michealle, tell us about this legislation, how much funding was cut, and what does it really matter?
So let's go back to the 1970s when the Impoundment Control Act of 1974 was enacted. It created a rescission process that allows a president to propose clawing back funding that Congress has already appropriated and approved. So under this provision, what is important to understand is first, Congress needs to accept it from the president. The president doesn't get to just do it unilaterally. However, it doesn't follow the same rules that appropriations do. So once rescission reaches the Senate, it can't be filibustered. And so that means it only needs 51 votes to pass rather than what would be a usual 60, subject to ending a filibuster. And so the Rescissions Act of 2025 is both a return to historical practice and a major departure from recent norms. So between 1974 and 2000, presidents of both parties used rescissions. So it wasn't completely out of the norm. It was bipartisan. Different presidents, different parties used it. However, it hasn't been effectively used, or successfully used, I should say, since the Clinton administration. So while President Trump did issue rescission requests in his first term, it wasn't until this year, 25 years later from the last time it was successfully used, that Congress accepted a rescission request from the president. So this means that there's an entire generation of lawmakers and nonprofit leaders who have never dealt with this process before. So with the Rescission Act of 2025, about $9 billion in previously approved funding was rescinded. And so through this act, Congress took back about $8 billion in international assistance and $1 billion for the Corporation for Public Broadcasting, which is the overarching organization for NPR and PBS. And so that process effectively eliminated federal funding for NPR and PBS through 2027. And so what makes this rescission especially significant is most of these funds were part of legislation that Congress approved in March of 2025. So we're talking about reversing agreements that required at least 60 senators to support, but now can be undone with just a 51 Republican vote. And so this creates real tension about how Congress operates going forward. And so Senator Patty Murray actually asked, how are we supposed to negotiate a bipartisan deal if Republicans will turn around and put it through the shredder of a partisan vote? And that concern reflects how much the political environment has changed since rescissions were regularly used. In today's hyper-partisan climate, using a tool that bypasses normal bipartisan processes carries a very different risk than it did, 2.5 decades ago. So what's particularly concerning for nonprofits is that the administration has already signaled that it'll likely send more rescission packages to Capitol Hill. And so this old tool is making a comeback as a regular way to adjust federal spending priorities outside of the traditional appropriations process. And so that creates a whole new level of uncertainty about funding stability that organizations haven't had to navigate in recent decades, if ever.
So how is congressional action different from executive action in terms of what nonprofits can do about it?
So this is a really important thing for nonprofits to understand because it really does fundamentally change their legal options. So when the executive branch acts, like the OMB memo or the NIH grant terminations, organizations can challenge those actions in court based on grounds like the Administrative Procedure Act wasn't followed correctly, arguing that agencies didn't follow proper rulemaking procedures or that their decisions were arbitrary and capricious. But nonprofits face a much steeper hill when Congress acts through legislations like they did with the Rescissions Act of 2025. Congressional action carries the presumption of constitutionality. And courts are very reluctant to overturn laws passed through the proper legislative process. So organizations can't simply argue that Congress made a bad policy decision. They need to prove that the law itself violates the Constitution, which is a much higher bar. So practically, when you challenge an executive action, the plaintiff can receive, a temporary restraining order or a preliminary injunction that previously would maintain funding while litigation proceeded. We saw this initially with the OMB memo freeze, but once Congress has rescinded funding through legislation, the money is simply gone. There's no judicial remedy that can force Congress to restore appropriations they've chosen to withdraw. And so this is why the Rescissions Act represents a fundamental shift in how the 119th Congress views its role. Traditional appropriations have largely been bipartisan affairs where lawmakers from both parties would negotiate funding levels for various programs. But this Congress has shown a willingness to use every procedural tool available to advance ideological priorities. So for nonprofits, this means that even if they successfully challenge executive actions in court, they could still lose their funding through congressional action. So organizations need to build political relationships and advocacy capacity, not just legal strategies, because Congress has shown its willingness to be an active participant in funding cuts and not just a passive appropriator of funds.
Next, let's discuss what all these actions mean in practice and how they will impact nonprofits. Devon, how did the Supreme Court's decision in CASA and the NIH grant termination fundamentally change the legal protection landscape?
So these two decisions fundamentally changed the landscape by restricting the scope of judicial relief and creating a complex jurisdictional barrier to recover terminated funds.
So can you describe the difference between the legal protections before CASA and after CASA?
Before CASA, a nonprofit not directly involved or not a plaintiff in a successful lawsuit could generally expect to be protected from the unlawful federal action because the result would be a universal or nationwide injunction. So it would apply broadly. After CASA, a nonprofit that's not a plaintiff would no longer be protected because they cannot make a nationwide or a universal injunction. So organizations that aren't party to these lawsuits may no longer automatically be protected by an injunction.
So I'm going to give you a hypothetical, Devon. What if
Okay.
an organization has their grant terminated? What is the process now? How many courts or what do they need to do to restore that funding, and how long will it take?
So this would go back to the jurisdictional split or the two-track litigation we discussed earlier. Plaintiffs would be forced to pursue different parts of their legal claim in separate courts. So they would have to take their policy challenge to the district court, circuit court, and that would be under the APA, the Administrative Procedure Act. The contractual claim, so the claim challenging the specific grant termination, would be filed with the Court of Federal Claims under the Tucker Act. And so court can be a long process. I think there's no saying how long it could take, but it's definitely a barrier that they weren't facing before.
I have a question about the NIH case. Experts say that it shows the Supreme Court's willingness to allow funding terminations even when lower courts disagreed. What is this signal for the future?
So the Supreme Court's decision to allow the termination despite the lower court ruling it was arbitrary and capricious sends a very clear signal that the court's demonstrating they prefer to enforce form channeling statutes like the Tucker Act over intervening to prevent potentially catastrophic consequences.
How are organizations adapting their operations to account for these uncertainties in the future?
Nonprofits, public health groups, and other organizations are adopting several strategies to deal with these legal and financial uncertainties. They are practicing data preservation, even internally, so they don't lose research and data they previously had. They are making fiscal and operational adjustments, which could include looking at their budget and either deciding to cut back on programs or whatever may be right for their business. And they're also starting to adopt stronger advocacy policies.
So, Michealle, based on your past life as a Capitol Hill staffer, what do you think the Rescissions Act says about our current 119th Congress?
So I really think that it tells us that the 119th Congress represents a fundamental departure from how Congress has traditionally approached appropriations. So in the past, even when members disagreed on policy priorities, there was a general respect for the appropriations process itself. But this Congress has shown a willingness to weaponize every available procedural tool to advance essentially ideological objectives. So We see this with the Rescissions Act because there were very narrow margins in the Senate that required Vice President Vance to break the ties. And we saw several last-minute vote changes in the House, which to me demonstrates that even within the Republican caucus, there's discomfort with these tactics. But the fact that they ultimately succeeded, despite this discomfort, really is very deeply concerning. So what we're seeing across all three branches of government is an unprecedented coordination in targeting nonprofit funding. So the executive branch is using ideological criteria to terminate grants. Congress is actively rescinding previously appropriated funds, and the Supreme Court is limiting lower courts' ability to provide broad protective relief. And so this isn't about policy disagreements anymore. It's really about systematic efforts to reshape the federal funding ecosystem. So as we look ahead, I believe this signals that nonprofits can expect continued volatility and politically motivated funding decisions. The traditional model in which organizations could rely on professional civil servants to make funding decisions based on established criteria really is being replaced by a model in which political appointees make decisions based on ideological alignment with administrative priorities. Organizations that serve, LGBTQ plus populations, that conduct research on health disparities or work on climate issues, or engage in any activity that could be labeled as DEI or woke, should expect to be targeted. But the criteria are so broad and poorly defined that virtually any organization could itself get caught up in these sweeps. And so the future of nonprofit funding will require organizations to be, one, much more politically sophisticated. They're going to need to be financially diversified, and they're going to need to be legally prepared for sustained challenges. So the day of assuming that good work and proper compliance will be sufficient protection, those days are over.
Based on all of your experience, Michealle, with nonprofit leaders, what are they saying on the ground about the costs associated with this new legal landscape?
So the organizations we work with are telling us that financial costs of this new reality really are staggering. But what we need to understand is it's more than, there are costs that are greater than financial costs. So what are the opportunity costs that are being lost? And really that's an important area because it's really quite devastating for organizations. We're hearing about research institutions that have had to lay off staff, clinical trials that have been terminated mid-study, community organizations that are shutting down entirely. And this isn't because their work isn't valuable or hasn't been valuable, that they've not been doing a good job, but it's because they can't afford the legal and operational uncertainty. In addition to that, hidden costs are really even larger. And so what I'm talking about here are the organizations that are self-censoring. So they're avoiding research topics, or they're avoiding serving particular populations or providing particular types of services, or even just speaking out about the impact of what's happening to them and the communities they serve because they don't want to draw that political scrutiny. We're seeing organizations that are abandoning multi-year strategic plans because they can't count on funding continuity. The transaction costs of constantly having to justify, defend, and potentially litigate their funding is also enormous. So there are several types of costs that organizations are facing right now, many of which aren't in a position to afford any of them.
So realistically, while these legal cases are playing out, how long should nonprofits expect to operate without federal funds?
So the harsh reality is that organizations need to prepare for years, not months, of potential funding disruption. The NIH grant case that Devon talked about, really shows us that what the timeline looks like. So grants that were terminated in February of 2025 for NIH grants, they were terminated in 2025. Researchers won district court victory in June, but then in August, the Supreme Court essentially sent back those cases to square one and in different court systems. So even if organizations ultimately prevail in the Court of Federal Claims, which is where as Devon explained, the Supreme Court has directed grant termination challenges, that process typically takes 18 months to 3 years. And that's assuming that organizations can find attorneys to work with expertise in federal contract law, because that's a vastly different area of expertise or specialization than nonprofit legal work. So you end up needing attorneys with different skills, capabilities, and knowledge while you work through these two court systems. So the tragic irony is that the organizations likely to be targeted for their non-alignment with the administration's priorities are actually the ones least equipped to financially sustain themselves during these extended litigation periods. So unlike large universities or health systems that might have reserves, smaller community-based organizations really can't operate for years without their primary funding source, which for many of them is federal funding.
So even if you're an organization and even if you have a really strong legal case, can they count on continued funding during the litigation process?
Not anymore. Because the Supreme Court's decision in the CASA case and the NIH grant termination case, organizations before that could obtain preliminary injunctions to maintain their funding while litigation proceeded, as Devon explained. But then the legal standard was whether they could show a likelihood of success on the merits and irreparable harm. And that criteria most plaintiffs could meet. But now courts can no longer provide that broad protective relief that organizations have relied on. So the Supreme Court has made clear that injunctions must be narrowly tailored to provide complete relief, but only to the specific plaintiffs, not similarly situated organizations. And for grant termination cases, the court has directed challenges to the Court of Federal Claims, which, as we've talked about, is not only a longer litigation period, but that court generally can't issue the kind of injunctive relief that would maintain funding during litigation. So this creates, a bit of a catch-22. Organizations need funding to continue operating while they challenge grant terminations, but the legal system can no longer provide that kind of bridge funding. So organizations may be forced now to choose between shutting down operations immediately or spending their remaining resources on litigation with no guarantee of relief.